This motion is the final opportunity to amend this legislation and would do so without any delay in passage. Madam Speaker, Republicans support protections in federal law for pregnant workers, and we believe employers should provide reasonable accommodations for pregnant workers. I support the provisions in H.R. 2694, which were previously outlined during the general debate. I also recognize that improvements to the bill were the result of bipartisan negotiations, and I commend Chairman Scott for his outreach in this regard. Unfortunately, despite our agreement on these changes, there remains an important outstanding issue that must be resolved. The bill before us today does not include a narrow but long-standing provision from the Civil Rights Act that protects religious organizations from being forced to make employment decisions that conflict with their faith. The motion to recommit adds this important protection. This very limited provision is already in current law, and it allows religious organizations to make religiously based employment decisions. Without this long-standing Civil Rights Act provision, H.R. 2694 will create confusion and legal risk for religious organizations in their religiously based employment decisions. At least 16 states in the District of Columbia, in their pregnancy discrimination or pregnancy accommodation laws, also include a provision similar to the Civil Rights Act religious organization protection. In fact, a Democrat-invited witness at a committee hearing highlighted Kentucky's recently enacted pregnancy accommodation law as a template for Congress to follow. Kentucky's law includes a religious organization protection very similar to the one found in the Civil Rights Act. At the Rules Committee hearing on H.R. 2694 earlier this week, the bill's sponsor, Chairman Nadler, said it is not necessary to incorporate into H.R. 2694 the Civil Rights Act provision that protects religious organizations. He stated that because H.R. 2694 does not repeal the provision, it will still be effective if the bill becomes law. At the same hearing, Chairman Scott said the religious organization protection should not be included in H.R. 2694 because it is over-inclusive and would provide too much protection. I strongly disagree with both of these perspectives, and I'm not sure Chairman Nadler's explanation is in line with Chairman Scott's position. Without the current law protection, H.R. 2694 will create legal jeopardy for religious organizations, as I have previously stated. But for the sake of argument, let's assume the provision is superfluous. Madam Speaker, what would the harm be in including the Civil Rights Act protection in H.R. 2694? At worst, the provision would be duplicative with the Civil Rights Act, causing no harm to workers or employers. At best, it will prevent a religious organization from being required to violate its faith. By adding this simple reference to H.R. 2694 from the Civil Rights Act, we can ensure the protections in the bill are harmonized with the protections for religious organizations found in the Pregnancy Discrimination Act, PDA, and the Americans with Disabilities Act, ADA. I would also briefly like to address recent claims made by the U.S. Chamber of Commerce, a trade association which represents few, if any, religious employers, that under this bill, required workplace accommodations would not come into conflict with the religious organization's beliefs. The Chamber acknowledges that leave, including paid leave, can be part of a reasonable accommodation under the ADA, from which H.R. 2694 incorporates the definition of reasonable accommodation. Therefore, if a religious organization has a paid leave policy, H.R. 2694 could require the organization to allow paid leave for purposes that conflict with its religious tenets. The Chamber also contends that H.R. 2694 is not a bill that addresses hiring, unlike the PDA and the ADA, which apply to hiring. This is false. H.R. 2694 applies to both employees and job applicants, and so it is indeed a hiring statute. Therefore, the religious organization protections in the Civil Rights Act and the ADA are just as relevant to H.R. 2694 as they are to those statutes. Madam Speaker, to conclude, the motion to recommit includes H.R. 2694 in its entirety with one important addition related to religious organization protections. My amendment simply incorporates the Title VII religious organization protections to ensure these organizations are not forced to violate their faith in making employment and accommodation decisions. I urge my colleagues to support this simple but important addition to the bill. I yield back.
The gentlewoman's time has expired. The gentleman